Hi. So if you sold your property prior to COVID or roughly before March of this year, and the due date for receiving the balance amount of the immovable property falls around in the month of May or a couple of months, and the buyer, if he tries to take advantage of the COVID situation and delays the payment to the seller after entering an agreement, what is the remedy that is available to the seller at this point of time is the topic of this video. Now, first things first, any agreement of sale must be registered. That is what the law says. You have to check whether if it is registered or not. And the burden to register the agreement of sale for an immovable property falls on the buyer, not on the seller. Buyer has to take steps to register the property. Even though it is an agreement of sale, it must be registered. That is what law says. And if he doesn't register, that document cannot be brought to the court as evidence. That property cannot be brought to court as evidence for the purpose of the transaction, that is sale of immovable property. But that document can be used as a document or an evidence for the purpose of recovery of money. Because generally agreement of sale, unregistered agreement of sale is done on 100 rupees stamp paper. For a promissory note, 1 rupee is sufficient. So it will be deemed to be understood in the eye of the law as a promissory note. Therefore, seller has to repay the amount to the buyer. If buyer takes this document to the court and files a suit called the suit for specific performance of the contract against the seller, then buyer will get only the money with interest. That's a bank interest. Buyer will not get the property because of unregistered agreement of sale. So this is the point that is to the advantage of the seller. The other ground which will fall to the advantage of the seller is to see whether there is any COVID clause in the agreement. If there is no COVID clause in the agreement, specifically COVID clause, there could be another clauses like force majeure clauses, like cyclones, earthquakes, etc. There could be clauses which are generally inserted into agreements. But because of the COVID situation, COVID clause must be inserted. If there is no COVID clause in the agreement, then it is to the advantage of the seller. Therefore, buyer will have to suffer the case against him if the agreement is not registered and if COVID clause is not there. If it is registered, COVID clause must be there. If it is not registered, forget about the transaction. This is point number 2. The third advantage to the seller is the buyer after the due date has to renew the agreement. He has to pay the agreement, pay the amount in the agreement, balance amount in the agreement, or it has to be renewed. The agreement has to be renewed. Whether it could be registered or unregistered, it has to be renewed. If it is not renewed, then again the situation falls to the advantage of the seller. Now, after the due date, let us assume it is not renewed. What happens in the court? What are the questions that will fall before the court? Court will definitely question the buyer what steps he had taken after the due date. Whether he deposited the amount in the account of the seller, or whether the amount that is to be paid to the seller is kept ready by him, because banks are functioning, post offices are functioning, courts are functioning. Only for a brief period, all these 3 institutions were closed. After that, what did the buyer do? Did the buyer take any steps to honor the agreement? Did the buyer take any steps to perform the agreement? Was the buyer honest or just taking advantage of the COVID situation? Courts will not allow if COVID situation is taken to advantage. Otherwise, it can be definitely be taken to advantage by the buyer, but not to the extent of blaming the banks, blaming the post offices, blaming the advocates. We are all functioning in the COVID period also. To a limited extent, we are functioning. Agreement can be renewed. Registration offices are open. To a brief extent, when all these offices are closed, buyer has to bring the evidence to the court that these institutions are closed and he took all the steps to make the payment, make the balance payment to the seller. He cannot take a blanket denial when all these institutions are functioning. Buyer cannot take a blanket defense against the seller. Therefore, seller is always at an advantage if the agreement is not registered, or if the agreement is not renewed, or if the payment is not received. Therefore, there is nothing to worry if buyer commits these kinds of mistakes. If buyer doesn't take steps, or buyer doesn't behave honestly with the seller and try to take advantage of the COVID situation, courts will not allow, is my understanding. Thank you. Thanks for watching. If you have any doubts, kindly comment.